while claiming somehow that the Constitution is binding and authorizes you to act against others, you're basically treating the document as a convenient talking point, an imagined source of imagined authority, the limits of which are determined only by yourself, right? Not by some exterior standard, but by yourself. Now this rationale that I just articulated, simply plagiarizing it from John Marshall and Marbury versus Madison, and to some extent from McCulloch versus Maryland, is not new to Marbury, right? It's also the rationale that Hamilton articulated in Federalist 78. It's the rationale George Wythe articulated while serving as a judge in 1782. Judges, Wythe said, should exercise judicial review to prevent the legislature from, quote, overleaping the bounds prescribed by the people. Right? Exactly what John Marshall said. Of course, Marshall was Wythe's student. Now, you may have heard that there are some people out there who believe that there are other methods of interpreting the Constitution. Now, my notes here say I should pause for boos and hisses. But I don't hear you. I was keep going. It's hard to believe that some people believe this, right? These people think they know more about the Constitution and how to interpret it than Marshall, Wythe, or Hamilton, right? And to take one example, maybe it's not the most powerful example, but Justice Brennan, right, said he was not bound by the original meaning of the Constitution. Instead, he believed he should interpret the Constitution so as to further, as he put it, human dignity, at least as he conceived of it. Now, other scholars criticize an original meaning approach without even offering an alternative approach, and I'll come back to that later. These people, ironically, embrace and take as a given the existence of judicial review, even sometimes citing Marbury as though it authorizes them to strike down the statute they don't believe is constitutional. But at the same time, they think courts ought to ignore the meaning that the ratifiers attributed to the Constitution. These folks, while perfectly nice people, I will say, right, they commit a fundamental error, right? They embrace the conclusion of Marbury that there is judicial review, while at the same time ignoring its premise, the premise that the ratifiers establish fixed, permanent principles to govern the future, principles that these judges should heed, right, not find some way to avoid. Put another way, these folks treat the institution of judicial review as a license, right, to ignore the Constitution, both striking down statutes that are perfectly constitutional, while at the same time enforcing other statutes that plainly violate the original meaning of the document. What these people don't understand, or don't want to understand, is that trying to have judicial review without Marbury is like trying to have judicial review without Marbury and without originalism is like trying to have Cheech without Chong, Steve McGarrett without Dano, Sonny without Cher, Captain Kirk without Mr. Spock, or Batman without Robin. I try to throw in some different references depending upon your age. You can't have both. You can't both say, I love judicial review, and at the same time say, I don't have to adhere to the rationale for judicial review and what it applies by interpretation. So someone who wants to depart from an original meaning approach to the Constitution can no longer rely upon Marbury as a license for judicial review. Instead, these anti-originalists must identify as binding some constitution other than the one adopted by the ratifiers. They must explain why this other constitution, whatever it might be, should be binding on us today. They must also explain why judges should be empowered to discern the meaning of this constitution instead of other actors who have greater democratic pedigree and greater deliberative capacity. And they must offer some theory of interpretation that places some limits on the discretion of judges instead of simply empowering judges to act as they please. And if these opponents of originalism don't satisfy these various necessary criteria I've laid out, then their alternative theory lacks any claim of legitimacy and is instead a glorified justification for elevating the rule of judges over the rule of law. And the alternative approaches to originalism that I know about completely fail this test. And in fact, many anti-original meaning approaches to interpretation really aren't theories at all. We'll talk about that in a second. Take, for instance, Justice Brennan's human dignity approach. So far as I know, and maybe Professor Klarman will correct me, Justice Brennan never offered an alternative rationale for judicial review for why the Constitution was binding to replace Marbury's rationale. He simply assumed the power to nullify democratic actions and then proceeded from there. He also assumed the authority to enforce statutes that contradict the plain meaning of the Constitution. Moreover, his overarching theory of interpretation, pursue human dignity, is entirely vacuous in most cases and places no constraint whatsoever upon a judge who is applying it. Take Roe versus Wade. How do we apply a theory of human dignity in Roe versus Wade? Texas asserts that the fetus is life, or potential life. therefore is human or a potential human, which has dignity. The mother asserts she has dignity. The father maybe even comes into play and asserts he has dignity. He wants the mother to carry the child to term. How does invoking human dignity help us solve that case? I don't think it does. It doesn't argue one result of the other, but I don't think it helps solve that case. What about the death penalty? How do you vindicate human dignity when the state wants to execute in the most humane manner possible an individual who's confessed to mass murder? Some say, like Justice Brennan, we vindicate human dignity by forbidding the death penalty altogether. Others say, no, we vindicate it by imposing it, the ultimate punishment on people who themselves ignore human dignity, maybe to deter future crime and protect the human dignity of others. Again, this theory of interpretation, pursue human dignity under the aegis of judicial review, is not a theory at all. It offers no methodology for deciding concrete cases. It simply empowers a judge to do what he or she pleases while pretending that they are exercising the judicial review that Marshall articulated in Marbury versus Madison. Now, maybe Professor Klarman will give us a different theory. I look forward to that in fact satisfies the various criteria that I laid out, among other things, actually constraining judges and allowing us to predict the result that those judges would reach, and therefore criticize judges for failing to follow their own theory. I'd like to take a few minutes here to address some of the arguments against originalism directly. Some say that we should abandon originalism because it results in adherence to the dead hand of the past. That government instead should belong to the living, and the ratifiers are all dead, and therefore we shouldn't really care much about what they thought. I think this argument proves too much. If we are going to ignore the decisions of the ratifiers about particular constitutional provisions, then why should we respect any of their decisions? Why respect their decision to create a Supreme Court? Why respect their decision to have judicial review? Why respect their decision to have a bicameral legislature, or to protect freedom of speech or the press, or freedom of religion? We have all of these institutions and these freedoms precisely because the dead hand of the past created them, and the dead hand of the past is binding for the reasons Marshall articulated in Marbury versus Madison. We constantly live according to the wishes of a dead hand. I teach antitrust law. I'm sure all of you will take it. The whole course is about a statute passed in 1890, even before there was an internet. If the Department of Justice indicts a cartel for price fixing, the members of the cartel can't say, whoa, it's 2010, man. Let's not live in the past. That statute was passed 120 years ago. Everyone who passed it is dead. Of course everyone is dead, but it's still completely binding. People go to jail all the time for violating statutes that were passed long before they were born and passed by people who are all now dead. It happens all the time. Now, let's say we did want to be governed by the hand of the living and ignore the dead hand. How would we do that? Would we turn our government over to 9 men and women with an average age of 76? And say, go forth and pursue human dignity, and give the Constitution its best moral reading, and then entrench their decisions under the doctrine of stare decisis? Is that what you would do? Or is that a representative group of people? The 9 lawyers on the Supreme Court? I don't think that it is. So if you really believe in a living Constitution, I think what that means is you defer to the legislature in all or most cases. It's also the case that even an original meaning approach, while relying on the dead hand, is often more flexible than some people suppose. So for one thing, the original meaning approach leaves most questions to the legislature. Most of the contested questions I'll mention today, like Roe versus Wade or the death penalty, are under an original meaning approach, left to the legislature. That's a living Constitution. It's also the case, that John Marshall said the ratifiers adopted permanent principles, not permanent results, but permanent principles. And originalists are perfectly happy to apply those principles in light of changed circumstances. So, for instance, agriculture may not have been interstate commerce in 1790, but it is today, because the agricultural markets are across state lines in a way they didn't in 1790. So today, you might be able to regulate agriculture in a way you couldn't under the Commerce Power in 1790. Now, some say originalism leaves too much discretion in the hands of judges because sometimes there are good faith disagreements about the original meaning of the Constitution, thereby allowing judges to apply their preferred policy outcomes under the guise of originalism. Now, the first response to this critique is, well, okay, fine, but compared to what? What other approach is there that's more determinative than originalism? Tell us what it is so we can compare it. I'm not sure what it is. But think about all the questions that an original meaning approach actually solves or actually answers. How many senators does Delaware have? How long is the term of a senator? How old do you have to be a senator? Can a state coin money? Can Congress reduce the president's salary? How many votes does it take to impeach a federal officer? These questions are all answered by the original meaning of the Constitution. Right? If you're worried about indeterminacy, imagine what happens if you have abandoned the original meaning approach. How do you answer any of those questions? I don't know. Right? How do you decide, as a matter of human dignity, how many senators Delaware gets? Right? Or how many votes it takes to impeach somebody? Okay? Even the most vociferous opponents of originalism, ironically, right, concede that when the text is as plain as the various examples I've just given, that text ought to control. Right? This suggests to me that many non-originalists are actually faint-hearted non-originalists. Right? That in 95% of the cases, right, where the text governs, they admit the text control. Well, why does the text control? Why is it my text that I handed to Dean control? Was it adopted by the ratifiers?